This is a real life case. Real life case. Imagine a scenario where, and I don't remember the numbers, so I'm going to make up some numbers here. But this is a real life situation that actually used to happen, and it still happens from time to time in other states, but not in California. But imagine a scenario where your house is going to be sold at a foreclosure sale. You owe $100,000 on that loan. The bank sells the house at the foreclosure sale, and the bank buys it at the foreclosure sale for $10,000. They do what's called a credit bid. Nobody else bids. The property becomes REO. You're familiar with that term, real estate owned. It's owned by the bank. Now the bank takes that property as REO, and they give it to their local Century 21 office. And what do the realtors at the Century 21 office do? They purdy it up. They purdy it up. They send people down to clean the carpet, paint the walls, make the landscaping look pretty, and they turn around and sell the property. Now the property sells for $100,000. The bank says thank you very much, and they put the $100,000 in their pocket. Then they go back to the former homeowner, the borrower. They say, when can we expect payment on our 90? Now the homeowner says, well, wait a minute. You just sold my house for $100,000. Why do I owe you anything? What do you think the bank's response is? Oh, no. You misunderstood. Your house sold for $10,000. Our house sold for $100,000. And then the banks would turn around and sue the borrower for $90,000. Oh, listen to the snickers out there. Listen. Did I tell you that there's some dirty pool that takes place out there? There is dirty pool. When you do not pay a lender, bad things happen. Bad things happen. Now, can the lender do that today in California? No, we got laws that stop that from happening. But here's what those laws are. Before a lender can hold a borrower to account for the deficiency balance, they have to provide the borrower or the homeowner with something called a fair value hearing. It's a hearing in a courtroom where both sides get to present evidence as to the value of the property. And then the judge does sort of one of these things. Okay? And he sticks a number on it. And whatever number the judge sticks on it, that's the number that's going to be used to calculate the deficiency balance. It seems fair, right? The banks, but here's the thing about banks. I'm going to go on a sidetrack here. I'm going to get sidetracked just a little bit. Not too far off, but just a little bit. I used to represent financial institutions and collection outfits and debt buyers and sue people for not paying their bills. Now here's one of the things that I learned over the 20 plus years I was in collections. If I sue 100 people, maybe 3 to 5 of those 100 people will actually defend themselves. The rest of them will ignore the lawsuit. And I will win by what's called default. The lenders know the game. They know the game. They will sue people knowing full well that the borrower has an affirmative defense to it. Knowing full well that if the defendant lawyers up with a competent attorney, that they could beat the claim. Why do they still sue on those debts? Because they know 95 out of 100 times the borrower's not going to do anything. So they win by default. Right? It is what it is. It's always been that way. It's that way today. It's going to be that way tomorrow. Now, going back to the fair value hearing. Well, the fair value hearing takes place in the courtroom. So there's a lawsuit pending. If the borrower ignores it, who's the only one presenting evidence as to value? The bank. Makes it real easy for the judge to do one of those things, right? Right. And then the legislature back in the 1930s said, hey, wait a minute, man. You guys are tricky fellas. That's bad. That's dirty pool. We got to do something. Because the borrower, had the borrower known that it was going to work out this way, they probably would have defended themselves. But by the time they realized how things worked out, it was too late. Their wages were being garnished. Their bank accounts had been empty. Now they got to go lawyer up, spend all sorts of money to try and undo the damage created by them ignoring the lawsuit. So the legislature said, okay, the homeowner shall have 1 year to repurchase the property for what it sold for at the sale. That's called a post-sale right of redemption. Post-sale right of redemption. And now the banks, to that, the banks did scream bloody murder. Wait a minute! How can we sell a property, an REO property, to anybody if the new buyer is subject to having his ownership disgorged and returned to the prior homeowner for a period of 1 year? It's a valid argument, right? Right. So what happened was the legislature essentially said banks will make you a deal. You walk away from the deficiency balance, and you do not have to provide a fair value hearing, and you do not have to provide a post-sale right of redemption. Bank said deal. Bank said deal. So, and that exists today. Today, if a bank wants to hold the borrower to account for the unpaid balance on the loan, they have to provide the borrower with a fair value hearing and a post-sale right of redemption. These take place inside of what is called a judicial foreclosure. It's a foreclosure that goes through the court system. In a non-judicial foreclosure, there is no fair value hearing. There is no post-sale right of redemption. Therefore, there is no obligation to pay on the loan. In a non-judicial foreclosure, it is when the trustee, under the deed of trust, exercises his power of sale, that protection springs into existence. In a non-judicial foreclosure. The vast majority of foreclosures are non-judicial. But we do see judicial from time to time, but the vast majority are non-judicial. And you know it's a non-judicial because you see a notice of default, you see a notice of sale, and it's who is it that's noticing the default and who is it that's noticing the sale? It's the trustee. It's the trustee. And when the sale is completed, no obligation to pay on that loan that's referenced in the deed of trust. Now, what happens? Now the banks are tricky fellers. They really are. Now, next thing you know, we're starting to see loans where the banks are right, on the purchase of a property. How many of you have seen those 80-20 splits? Yeah. 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 And the banks, I'm telling you right now, there's people inside of the banks going, you know, if we break this loan up into 2 different loans, then we foreclose on the first, that we can still sue on the second. And that way we don't have to provide the borrower with his right to a fair value hearing and his post-sale right of redemption. We completely circumvented that. Brilliant! That thinking has taken place. It does take place. They're thinking about how are they going to get their money. Now, the courts, though, didn't respond very favorably to that effort. And the courts, the appellate courts within the state of California, have held banks, if you are deliberately trying to circumvent California's anti-deficiency statutes, we're not going to aid you in doing so. So if you have a first, if the bank, same lender, originates the first and the second in successive order without an intervening loan in between them, then when the first forecloses non-judicially on the first, then under 580D, they're going to be barred from collecting on the second. This getting complicated?
Yeah.
Heck yeah! Now I'm going to complicate it even further.